Right, imagine this, you're deciding to dissolve your company, you think you've done absolutely everything by the book, a few months later you're hit with an unexpected fine or even legal action because of a mistake you've made during the striking off process, especially if your company had debts. Sounds like a nightmare? Well, it is a reality for many directors who don't fully understand the process. Now in this video, I will make sure that this does not happen to you. Hello, welcome back to the Director First channel. My name is Chris Worden and I'm going to dive into a crucial topic for any UK company director thinking about closing down their business and using the strike off or dissolution route. Now just so everyone understands, striking off a company and dissolving a company is pretty much the same thing. Now, whether you're winding it down because it's no longer viable or you're simply ready to move on to new opportunities, it doesn't really matter. Understanding the correct process is essential to avoid any legal or financial pitfalls, because there is a lot of bollocks out there on the internet about this subject. And here is the kicker. If your company has debts, this process becomes even more critical with a few extra steps that you must take to protect yourself. So, in the next 15-20 minutes, I'm going to walk you through every aspect of striking a company off, including what to do if your business has some outstanding debts. This information, I promise you, you cannot afford to miss it. So, let's start the start. What does it actually mean to strike off or dissolve a company? Now, let's clarify that. If you want to dissolve or strike off a company in the UK, it means it's the process of removing that company from the company house register, effectively dissolving it. It disappears. Now, once dissolved, the company ceases to exist as a legal entity, meaning it can no longer trade, it can't own assets, or it can't incur liabilities. Now the process, it's far from just filing out a form. Like I say, there's a lot of nonsense out there about how you do this. There are specific legal obligations that you must meet, especially if your company has some debts, to ensure the process is completed without any lingering issues. Now, we've got to ask the question, is striking off the right option for you? You know, before you actually begin this process, you need to determine whether striking off is the best option for your situation. Because striking off is typically suitable for companies that are no longer trading and have no outstanding debts. They've distributed all their assets, they've paid off all the debts, or they never really traded. But if your company has debts, this complicates this matter significantly. Now, in cases where you've got some debt and you're still trying to strike your company off, you must, please listen to this, you've got to approach the process carefully. If you strike off a company with outstanding debts without informing your creditors, it can lead to legal issues and personal liability. Now, your creditors have the right to object to the strike off, and if they're not properly informed, they might take action against you or apply to have the company restored. So, let's move on a little bit. Let's prepare to strike the company off with debts. Let's imagine you've got a limited company and you owe 20 grand to the HMRC. Okay? Now, what you need to do, there's a detailed checklist of what needs to be done before applying for strike off. Now, I said before, there are extra steps if your company has got debts. Right? If you've got debts, this is what you need to do. Communicate with creditors. It is crucial you notify all the creditors about your intention to strike the company off. This means anyone the company owes money to, suppliers, HMRC, landlords, other stakeholders, you've got to inform them in writing, and it basically gives them a chance to object, or actually they'll pay for they could get the business wound up. Another thing you've got to do, if you can, is settle the debts, okay? So where possible, you need to aim to settle all outstanding debts before you apply the strike off. This pretty much reduces the likelihood of anybody actually objecting to the strike off and hopefully helps you avoid any legal repercussions down the line. Remember, if you cannot fully settle the debts, You might want to discuss payment plans or other arrangements with creditors before you go for the strike-off. You know, there might be other alternatives. You know, if your company can't pay its debt, striking off might not be the right solution. It definitely isn't if you've got a bounce back loan. Because if you've got a bounce back loan and try and strike the company off, the bank will just object to the strike off, and you'll just go around this merry-go-round forever and a day. Might change in the future, but in September 2024, you can't strike a company that's taking a bounce back loan. And if you do, or if you did recently, that people are getting into serious consequences. Let's have a quick drink. You know, another option to strike off is a creditor's voluntary liquidation. If you've got debts, one of the things you might be better off doing is putting the business into liquidation or administration. And that's where you have to find an insolvency practitioner to help manage that process, okay? And in that scenario, it's going to cost you money, okay? Now, let's dive into how, if you've looked at everything, you think, right, no, Chris, I'm going to dissolve the company, right? There's a process you need to follow called filing the DSO1 form, right? So once you've taken all necessary steps, especially regarding any debts, right, you've got to inform the creditors that you're going to try this process. It's then time to file the DSO1 form with Companies House. It's basically a formal application to strike the company off, and here's what you need to know and put on there. First of all, you're going to need to put the company name and number. Ensure these match exactly with the records at Companies House, okay? You're going to have to get directors' signatures. A majority of directors must sign the form, and you're going to have to do a declaration. You'll need to declare that your company has ceased trading, settled all debts if it can, and informed all relevant parties. So that means if you owe HMRC, you've informed them that you're trying to do this dissolution, okay? Once you submit the DSO1 form, Companies House will publish a notice in the London Gazette, and it basically announces your intention to dissolve the company. Your creditors then will have the opportunity to object if they feel like they've not been properly informed about this, right? Sort of goes on to my next point. There's a 3-month waiting period, okay? After filing the DSO1 form, there is a mandatory 3-month waiting period. And during this time, the notice in the London Gazette serves as a public warning that your company is about to be dissolved. This period is crucial, especially if your company had debts. Now, your creditors can object to the strike-off during this period if they believe that they're owed money or if they believe they weren't properly informed. If an objection is raised, Companies House might suspend the strike-off process until that matter's resolved. And this is why it's essential to have communication with your creditors. Before you even submit that DSO1 form, you want to be writing to your creditors to let them know what you're intending to do. Now, if you file the form, there's the advertising period and your company's struck off, what happens after then? Well, listen, let's dive into it. If there's no objections raised during that waiting period, Companies House will strike the company off and it will cease to exist. It dissolves. And this is what you need to do next. Retain records. Keep all company records for at least 6 years. You're required to do that by law. This includes financial statements, meeting minutes and correspondence with creditors. You might have to deal with some late claims. You know, if a creditor discovers they're owed money after the company's been dissolved, they can apply to the court to have the company restored to the register. Now, this could result in personal liability for any unresolved debts. It doesn't happen very often, but it does happen. There's obviously the risk of personal liability. If you found that you dissolved the company without properly settling debts or notifying creditors, you could be on the line. And that's why it's crucial to follow the correct procedure and communicate transparently with all parties involved. Now, I'm going to talk about now the pitfalls of striking a company off with debts, okay? When you strike a company off with debts, it's not absolutely straightforward, and there are several things that are going to perhaps bite you in the arse. Now, if you don't inform the creditors, if you fail to notify creditors, it's one of the biggest mistakes a director can make, because this can lead to objections, it could delay or halt the process entirely, failing to settle certain debts, sort of trying to attempt to dissolve a company with unpaid debts without addressing them properly, like we've said previous in the video, it can lead to serious legal consequences, including like personal liability. A lot of directors overlook the waiting period. You know, they assume the process is complete once they've filed the DSO1 form, but the 3-month waiting period is critical. Any objections raised during this time must be dealt with immediately. But if you're aware of these pitfalls and you're taking steps to avoid them, you can ensure a smooth and compliant dissolution process. So listen, striking off a company, especially one with debt, is a process that requires careful planning and attention to detail. From settling debts to notifying creditors and navigating the 3-month waiting period, every step's crucial to ensure a smooth dissolution. If you're considering striking off your company, take the time to do it right. Let your creditors know what's happening, okay? Follow the legal process. And if you found the video useful, please like, share, subscribe to the channel. Thanks for watching. I'll see you in the next video. Worden, Director First.